Please, can you confirm that you can see my screen?
Yes, very clear. You can share now.
This. Sorry, I'm trying to put this on slide.
So, to our audience on Facebook and on Zoom,
okay.
Okay, go ahead, please.
Okay, so thank you, Omar. Good evening, everyone, once again. Thank you for having me to do this. And it's really going to be an insightful discussion around the newly minted Data Protection Act. So we are going to be doing a deep dive into the act. And in relation to how I'm going to approach this, I will be doing this based on broad themes. So we are going to be looking at the introduction. We will look at the objectives of the act. We will also deal with the scope of the act and the exemptions that we have under the act. Then we will define key terms that will be used in the course of our presentation today. We will look at the commission that has been established under the act. We will also look at the principle guiding the processing of personal data, as well as the legal basis. We will look at a subset of data known as sensitive data and how they've been adequately safeguarded and hardwired into the act. We will look at the rights of data subjects. We will deal with cross-border transfer of data. And after that, we will consider the obligation that have been imposed on data control and on data processor of major importance. Then we'll wrap up with enforcement. So in terms of the introduction, data protection, when you look at the foundation of data protection, it essentially deals or stems from the Constitution. So specifically, Section 37 of the 1999 Constitution recognizes and guarantees the right of rights to privacy of citizens of Nigeria, whereas Section 42 deals with freedom against discrimination for citizens of Nigeria. The African Charter of Human and People's Rights even took it a step further to provide for rights against discrimination for individuals. So if you look at the Constitution, for instance, you will realize that the coverage is in relation to citizens, whereas under the African Charter for Human and People's Rights, with specific reference to the rights against discrimination, it deals with individuals, meaning both citizens and non-citizens. So so after dealing with the legal framework or having a situation where the right to privacy is constitutionally guaranteed, the question that one may want to ask is, why do we need a data protection law that this right is already constitutionally guaranteed? Is there any need to have a framework that indeed deals with data protection? Is it necessary? What is the utility? The answer to that question is that it's not sufficient to have a blanket right to privacy under the Constitution, because the Constitution does guarantee these rights. It doesn't have granular provisions on how these rights should be safeguarded. So what the data protection law does is to provide for adequate measures that will ensure the integrity, security, confidentiality of the personal data of data subjects. So it regulates the processing of personal data. So it's not sufficient just to have blanket right under the Constitution, but you would indeed need to have this right safeguarded and protected such that we don't have incidences of data breaches. So that's exactly what the Data Protection Act does. Now, prior to the enactment of the Data Protection Act, we had several efforts or several interventions that have been made by the government to indeed have a legal framework to protect personal data. So before now, what we used to have was like fragmented laws in different sectors that deals with data protection. So you would have like sector-specific law that have provision on data protection. You also have subsidiary law, which is the NDPR that deals with data protection. But the issue with the NDPR is that it's a subsidiary law, and in terms of the hierarchy of laws, if there is any conflict between the NDPR and a primary or sector-specific law that also has provision on data protection, then the sector-specific law, that is the primary legislation, is going to trump the NDPR. So because of that concern, there was indeed a need at the time to have a legal framework to adequately protect personal data. And specifically in 2010, Nigeria actually signed the ECOWAS Supplementary Act on personal data. So what this act essentially does is to recognize or afford protection of personal data for members of ECOWAS. Specifically, Article 2 of that act actually requires member states to have a legal framework for the protection of personal data. And in fact, Nigeria was even sued for not having a legal framework for relation to the protection of personal data, even though the ECOWAS court held otherwise anyways. But at the relevant point when we didn't have a data protection law, Nigeria was actually sued before the ECOWAS court for not having a data protection law. So in terms of the journey, or where we were coming from and where we are today, in terms of the journey towards having a data protection law, this journey started in 2015. And that journey crystallized into a data protection bill of 2018. Unfortunately, that bill was not assented to by the president. And in 2019, the National Information Technology Development Agency, NITDA, which is the statutory body that deals with ITC-related matters, issued a data protection regulation, Nigeria Data Protection Regulation, which is the NDPR of 2019. As I mentioned earlier, this is a subsidiary law. So even though it was a good starting point for Nigeria, it didn't really give us that adequate protection that we wanted, because we needed a primary law, a law from the National Assembly that will adequately address issues relating to privacy, issues relating to data protection. And so the efforts towards having a data protection law continued post the NDPR. In 2020, another development occurred, and that crystallized into the Data Protection Bill of 2020. Unfortunately, the president did not assent to that bill. And specifically in 2022, February 4th, the president approved the establishment of the Nigerian Data Protection Bureau, which who literally assumed the responsibility of NITDA in relation to data protection. So essentially, the responsibility of the Bureau at the time was to administer data protection using NITDA-related regulations. So what was paramount at that relevant time was indeed to give a statutory coverage for this bureau, because it was just a mere establishment or an indication for the establishments to be formalized through a legal process. So it was indeed key to have a legal framework for data protection. So finally, the efforts crystallized into an act that we presently have today. Specifically on the 4th of June, 2023, the president assented the Data Protection Bill of 2022 into law. And that act is exactly what we are going to be considering. Now, in relation to the act, so essentially the act has like 12 parts. It will have about 66 sections and a schedule. And some of the core provisions of the act is what we are going to be considering today. First is in relation to the objectives of the act. So as I mentioned earlier, core to data protection is the need to safeguard the constitutional guaranteed rights to privacy. So the Data Protection Act, what the objective sets us to do is to safeguard the fundamental rights of data subject as guaranteed under the Constitution. Another objective of the Data Protection Act is also to provide a legal framework for the processing of personal data. So essentially to regulate how personal data should be processed by data controller and data processors. So other than that, he also established an authority or a commission that will supersede, that will literally oversee the affairs of data protection related matters in Nigeria. And that is the Data Protection Commission that we are going to be examining in subsequent slides. So in relation to the application of the act, so we are going to be looking at the scope of the act in terms of the coverage, who the act applies to, and who exactly, or the nature of processing activities that are not covered under the act. In relation to the application of the act applies to the processing of personal data of data subjects, whether it's automated or is not automated, in different circumstances. One is where the controller or processor is domiciled or resident or otherwise operating in Nigeria. So literally, if you have a controller or you have a processor that is resident or operating within Nigeria, then that controller or processor has a responsibility to comply with the Data Protection Act. So another scope that we have under the Act is where the processing of personal data occur within Nigeria. So if you have a controller or you have a data processor that is perhaps not resident in Nigeria, but is processing the personal data of a data subject in Nigeria, that act will be covered, and that data controller or processor will be required to comply with the provisions of the act. Another instance, another coverage that we have under the act is where the data controller perhaps is not resident or domiciled in Nigeria, but is processing the personal data of the data subject that is resident in Nigeria. So in that instance, we are talking about offshore entities. So if you have a data processor that is in the US, for instance, or in the UK, for instance, and they are processing data of data subject that are in Nigeria, so the data controller or data processor in that circumstance will be required to comply with the provisions of the Data Protection Act. It doesn't matter the nationality. The nationality of the data subject is actually immaterial. So whether the data subject is actually a citizen of Nigeria or is a non-resident, to the extent that the data subject is in Nigeria or is resident in Nigeria at the point where that processing activity was undertaken by the offshore entity, the offshore entity has a responsibility to comply with the data protection laws of Nigeria. So one thing or one takeaway from this scope is the fact that if a citizen of Nigeria is actually outside Nigeria, and in circumstances where the controller or the data processor is also outside Nigeria, that activity will not be covered within the Act. So in other words, the Act does not apply to the processing of personal data of citizens of Nigeria that are outside Nigeria by a data controller or data processor that is also outside Nigeria. So in that circumstance, the provisions of the Act will not apply to that processing, unlike what we have under the NDPR. Unfortunately, this wasn't covered. So in terms of the exceptions, the Act does not apply to processing of personal data in the context of domestic relations. So if I'm processing personal data in the context of household activities, so I'm processing the personal data of my husband, for instance, or my kids, for instance, that will not be covered. So that doesn't fall within the ambit of the Act. So having considered the scope and the exemptions, we're also going to be looking at key terms that we are going to be using in the course of our presentation. And one of those terms is data subjects. So I've been using the term data subject, and it's good to also explain what that literally means. A data subject is a natural person, so you and I. And what that literally means is that a data subject in that circumstance cannot actually be a company. So a company cannot be classified as a data subject. So a data subject is an individual, a natural person to whom personal data relates. So it doesn't apply to companies. However, the employees of a company can be a data subject because they are literally human beings, they are natural persons. So they fall to be classified as data subjects. But the company is not a data subject. So in other words, the company cannot actually bring an action for the violation of data privacy in the context of the Data Protection Act. However, the way this is typically done is that the company will have safeguards under contractual mechanism. So it is advised that for you to have as a company, when engaging third parties, that you should have adequate protection in relation to your contractual arrangements with that third party. So you can have confidentiality clause that you can always fall back to. So in the event of any breach, you can go to the court, you can actually maintain an action for the breach of the terms of that agreement, because that agreement contemplates that information or whatever relationship that you have with that counterparty must be safeguarded or protected. But in the context of Data Protection Act, that activities will not be protected because a company is not capable of having a personal data within the context of the Data Protection Act. However, as I said earlier, the employees of a company are natural persons, and so they can have their data protected. So in that context, the employees can sue the employer where there is any data breach. So another term that we are going to be explaining is personal data. So I've talked about personal data in several instances. So it would be good to explain what that connotes. So personal data literally is any information relating to an individual who can be identified or who is identifiable. Now the key words are identified or identifiable. Data subjects can be identified directly by name. So you can actually identify me directly by my name. You can also identify me indirectly by reference to my identification number. Data subjects may also be identifiable where information, when used alone or in combination with other pieces of information, may allow the data subjects to be distinguished from others. So what does that mean? So a good example is my my car registration number. So my car registration number, without more, on the face of it, does not immediately identify me. So anybody that doesn't know my car registration number, for instance, will not know that that particular number belongs to Celestina. However, if you take that car registration number to road safety, what literally happens is that, or what would happen is that the road safety can indeed track the number and locate the person that registered that car. So in that circumstance, they can track that number and locate me and attach me to that number because I was the one that registered that car. I own the car and I registered that car. So that means that data is capable of identifying me, and that is exactly why it's called identifiable data. So even though on the face of it, you cannot identify me with that data, but with additional information or with additional circumstance, you can actually identify or link that particular information to me. Another example is my signature. If, for instance, before this webinar, Umar projected my signature, being that nobody knows my signature, you wouldn't immediately identify or link that signature to me, right? Without more, you wouldn't say that that signature belongs to Celestina. However, for someone that knows my signature, the person would be able to identify or perhaps say that that signature belongs to Celestina. So that signature is actually an identifier. So it's capable of identifying me, and to that extent is protected. Another example is maybe your IP address. So your IP address without more doesn't identify you. But however, if you use that IP address and perhaps go to an internet service provider, they will be able to perhaps track the equipment or the computer to which that IP address is attached. And in so doing, they can locate me with that data. And that's exactly why my IP address will be an identifiable data in that circumstance, and is protected for data protection purposes. Another term that I would like to indeed explain, or the terms that I would like to also explain, is anonymization and pseudonymization of data. So the act does not apply to anonymization, but it applies to pseudonymization, and I will explain why. Anonymized data is literally a data that has been rendered anonymous. So it doesn't relate to anybody. So you can't link that data to an individual. Recall that I mentioned that personal data is any information that relates to an individual who can be identified or is identifiable. So with anonymized data, you can identify that individual. You can link that data to an individual. And so it doesn't come within the ambit of data protection. However, for pseudonymization of data or pseudonymized data, that data comes within the ambit of data protection because it is possible to indeed link that data with somebody with additional information, and I will explain. So for pseudonymized data, for instance, so it relates to processing of data in a manner that the data cannot be attributed to the data subject without additional information. So literally what happens is that the personal data is replaced with pseudonyms. And that pseudonyms can be reference number, it can be values, it can be any description, in such a manner that you cannot immediately link that data to another person or to a particular individual, to an identifiable individual without an additional key or additional information. And I will give you an example. Let's say Umar decides to perhaps keep attendance or take record of people that attended this meeting or this webinar rather. So what happens is after taking the attendance, the names, the telephone number, and other information, I requested for that information. And Umar, as opposed to sending me that information, decided to convert the information to pseudonyms. So when I got the information, literally what I saw is attendee 1. And in terms of the telephone number, it was described as SS, or maybe it was described as 111, right? On the face of it, I'm not immediately able to say that this particular person is Celestina or this particular person is John. I would need additional information from Umar to be able to de-identify that data so that I can relate it to a specific person. So that is exactly why it is protected, because with that additional information, you'll be able to relate that data to a specific person. And that is exactly why I said that it comes within the ambit of data protection. So another term that we are going to be using in the course of our discussion is data controller and data processor. So a data controller is an individual or private person or public companies or commission, agency, MDAs that jointly or alone determine the means and purpose of processing of personal data. So the core terms is the fact that the person determines the means and purpose of processing of personal data. So if in your organization, for instance, you determine how the data of customers should be processed, how the information about customers should be stored, how long it should be stored, and for what purpose that information should be processed. So literally in that context, you can be classified as a data controller because you determine the means and purpose for the processing of that particular data. A data processor, on the other hand, is someone that has been engaged by the controller to process on its behalf. So the data processor does not determine the means and purpose, rather is processing on account of the controller. However, in practice, that fine distinction is a bit difficult. So there's this thin line in terms of determining who a processor is or who a controller is, particularly in the context of data breach. I will give an example. So let's say I engage Umar to help me with my recruitment efforts, and I have a processing agreement with Umar, and perhaps I shortlisted one or two candidates that he should interview. In interviewing those candidates, Umar determined the questions to be asked. He determined how the information about that candidate should be archived, how long it should be archived in the system, how the information should be processed, how the interview is going to go, or how the interview should be conducted. In that context, even though I have a processing arrangement with Umar in that context may not be adequately or properly classified as a processor, because even though I have a processing agreement with him, he also determines the means and purpose for the processing of that information. So in terms of the practical challenge, what we've seen in practice is that when you have a real life issue, it may be difficult to say who determined the means, who determined the purpose, and where is the distinction, where does it lie? So what our Act did, or the approach that has been taken in terms of the Data Protection Act, is to impose the same obligation on both parties. So whether you're a controller or whether you're a processor, you have the same obligation in terms of complying with the data protection laws. So the essence of this is because of the practical challenge that I explained to you earlier, because sometimes it may be difficult to determine who indeed is making that determination. Is the controller, is the processor indeed a processor in that strict sense? Or is the processor also taking additional information or responsibility and can be recategorized as a controller? So because of that distinction or that issue in terms of the practice, what the Act did, or what the Act has done, is to indeed impose the same obligation on both parties. So the Data Protection Act established the Nigeria Data Protection Commission. So the Nigeria Data Protection Commission is to superintend data protection and privacy-related matters in Nigeria, and also to supervise data control and processors. Also, the data commissioner or the Nigeria Data Protection Commission receives complaints from data subjects, or is charged with the responsibility of receiving complaints from data subjects in relation to data breaches. So if you think that your right has been violated under the Act, you can lodge a complaint before the Data Protection Commissioner, and that complaint will actually be taken up. Another responsibility or power or function that has been conferred on the Data Protection Commissioner is to issue compliance order or enforcement order against any data breach to a data controller or data processor. So if there is an alleged infringement, an enforcement order can be issued by the commissioner to the data controller or data processor. And we are going to be looking at that in subsequent slides. Then another responsibility or function of the Nigerian Data Protection Commissioner is to register data controller and data processor of major importance. So this is a term that was used in the Act, and I'm going to be explaining that in subsequent slides. Now, core to data protection is the principles underpinning the processing of personal data. So the Act in section 24 sets out the principles that should indeed guide, and principles that must be complied with by a controller and a processor in the processing of personal data. One of those principles that the Act indeed recognizes or provides for is the fact that data must be processed in a lawful, fair, and transparent manner. I'm going to unpack these three concepts. So in relation to lawfulness is literally just saying that you must have a legal basis for the processing of personal data. So you can't just process personal data when there is no legal basis. And that processing must be in accordance or in tandem with the terms of the legal basis. And the Data Protection Act indeed set us what those legal bases are. So we're going to be looking at that in the course of our presentation. The principle of fairness literally is saying that the data subject should be informed that his or her data is being processed to enable the data subject to take an informed decision and indeed exercise his or her rights. So if you're processing my data, you should let me know that you're processing my data to enable me to take an informed decision and also exercise my rights, whether the rights to object, the rights to ask that you shouldn't proceed or restrict the data processor from indeed proceeding with the data, with the processing of that personal data, or even after processing the rights to even ask for erasure of that personal data. So indeed, you need to let me know that my data is being processed to guide me in making an informed decision and also to exercise any rights that I have. This principle of transparency is literally saying that you should be open, you should be clean, it should come clean and open to the data subjects. So they should know everything about that processing. So the intended processing must be disclosed in every manner to the data subjects. The way this has been operationalized in the Act is through the issuance of privacy notice. So if you look at the Act, specifically section 27, it imposes an obligation on data controller and processor to indeed issue privacy notice prior to processing personal data. So before you can process personal data, you have an obligation to issue me a privacy notice. That privacy notice will literally contain information about the data controller or data processor, where my personal data is going to be disclosed to a third party or will be shared to a third party, particularly in the context of cross-border transfer. That must be disclosed. Also, you should disclose in your privacy notice the legal basis for the processing of that data and the rights of the data subjects in relation to that intended processing, including the rights to object, including the rights to even lodge a complaint before the commission that has been established under the Act. Where the processing is going to entail automated decision-making, I'm going to be explaining that subsequently. That must also be disclosed to the data subjects. The whole essence is that I have full visibility of what I'm indeed consenting to. I have full visibility of the intended purpose for that processing. And if I don't want that processing to indeed be carried out by the data controller or data processor in that circumstance, I can object. And that's exactly why it is indeed needed. Another purpose, another principle that is recognized under the Act is the purpose specification. So that principle is to the effect that personal data should be collected for specific, explicit, and legitimate purpose. So if you're processing personal data, you must have a specific purpose in mind. You can't just process data without any intended purpose. Your purpose must be clear, it must be explicit, it must be legitimate, and it must be specific. And where personal data is to be further processed, the further processing must indeed be compatible with the original processing. I will give you an example. If, for instance, I perhaps applied for a job with a recruiter, and I gave my personal information, literally just filling the form with all my personal information. And at the point when I was about to submit, I was asked to consent to whether my personal information should be retained and perhaps used for subsequent notification of any vacancy. And I indeed consented. Then subsequently, maybe two weeks down the line, I started seeing adverts of the recruiter's products, emails on their product or in relation to their products. That will not be compatible with the original reason why I availed my data in the first place. So what this principle is saying is that what I've given my data or the concept that I've given in relation to that processing is in relation to future recruitment efforts or future recruitment opportunities. So you're supposed to be sending me job links, you're supposed to be sending me openings or job opportunities, and not to send me adverts on your products. So that's exactly what this principle is saying. So you must have a specific, explicit, and legitimate purpose. And even when you intend to further process that data, the original processing must be compatible with the further processing. Or rather, the further processing must be compatible with the original processing. Now, the third principle is the principle of storage limitation. So what this principle says is that data should not be held longer than is necessary. So it literally should not hold data longer than is necessary. Now, the way this is operationalized is the fact that if you go through the privacy notice requirement under the Act, there is a requirement to indeed disclose how long you'll be holding the data subject's data at the end of the day. So your privacy notice, you're supposed to indeed estimate your storage period in relation to that particular data. So what that literally means is that data processor and data controllers are required to have retention policy. In formulating your retention policy, you are required to also comply with the provisions of the law, particularly for regulated sectors. So you have regulated sectors wherein wherein data should indeed be retained for a specific period. So in formulating your retention policy, that must be consistent with what the law says regarding that particular sector. Another principle is in relation to data minimization. So what data minimization speaks to is the fact that you should only collect the data that is necessary, relevant, and adequate by reference to the purpose. When Martins gave his presentation last week, he talked about an NGO that was doing a survey in relation to malaria, and they were asking all manner of questions that is not connected directly or indirectly to the survey that they are even doing in the first place. So that will be a breach of the principle of data minimization. And another example is if, for instance, Umar wants to maintain the record of people that attended this webinar, and he then decided to include as part of the information that will be populated by the attendees, their marital status, how many kids they have. That is completely irrelevant in relation to maybe sending them future notification for further webinars. That is completely irrelevant. And in that circumstance, you can sue Umar for breach of the right of the principle of data minimization. So literally, if you're processing or collecting information, only collect what is necessary, relevant, and adequate by reference to the purpose of that particular processing. So it frowns at collecting excessive data that is not needed in the first instance. Another principle that is recognized under the Act is the principle of accuracy. This principle speaks to the fact that the data controller or processor must ensure that whatever information that they have about the data subject is accurate and, where necessary, up to date. So you don't have to maintain inaccurate information about me. Now, the way this is operationalized in later provisions of the Act is that the data subject has a reciprocal obligation, or right rather, to request that any erroneous information that is maintained by the controller or processor should be ratified. So if I notice that you have erroneous information about me, I can ask that that data should be corrected to reflect an accurate information in relation to what indeed you should capture in the first instance. So another principle that we have under the Act is the principle of data security. So this principle speaks to the fact that data controller or data processors must ensure the security, integrity, and confidentiality of personal data, and also protect that personal data against unauthorized processing, accidental loss, or disruption through the use of appropriate technical and organizational measures. So literally what this speaks to is that as a controller or as a processor, you must adopt adequate technical measures to ensure the security, confidentiality, and integrity of the personal data in your custody. Not just adequate technical measures, even organizational measures, and I'm going to be explaining those. So for instance, I talked about pseudonymization. So for pseudonymization, for instance, it deals with is a technical tool or a technical measure that can be used to protect personal data. So the example that I used earlier regarding Umar maintaining the records of this meeting or attendance of this webinar and sending me the attendance list, and then using pseudonyms to describe the personal data of what he captured. In that circumstance, I'm not able to immediately identify anybody, right? So that is a way to indeed safeguard the personal data of the data subjects, the persons that are affected by that particular record. So in your company or in your establishment, as opposed to having a situation where data can just be readable or accessible by everybody, you can indeed employ technical tool that would ensure that for you to even access any data, you need to have appropriate key. You need to have appropriate key from the relevant manager, from the relevant HRO, or from your boss to be able to access a particular file or a particular data. So this is one of the technical tools that can be adopted by an organization in this regard. Another technical tool that can be adopted is encryption. So when you talk about encryption, literally what happens is that data has been concealed by converting it into a code. So that data cannot be accessed without decrypting, except it is decrypted with the appropriate key. So you get an information, but you're not able to access it except you have maybe the password or you have the code to indeed open that data. A good example is your bank statement. I'm sure people get notification from their bank, or they get information from their bank regarding their bank statement. If you get your bank statement, you will not be immediately able to open it and read it. You definitely would need your password or some sort of code, right, to be able to access or open that data. So that tool is a technical tool that has been deployed by the bank to ensure that if peradventure that data gets to a wrong hand, then the person literally cannot do anything with it, but the person doesn't have that key to indeed have access to that particular information. So that is exactly what encryption talks about or deals with. Another technical tool that can be adopted by organization is having antivirus or literally having antivirus. So if you have antivirus, it ensures the safety of your system. It ensures that your system is protected against any attack. Another tool is authentication mechanism. And I will use WhatsApp to explain this. If you want to download WhatsApp on your phone, you would notice that you will get like a prompt to do two-step verification. Now, that is a tool that has been deployed to ensure that if somebody have access to your WhatsApp, without that password that you would have inserted at the point of creating that WhatsApp, the person cannot indeed be able to open or access your information on WhatsApp. So literally what this does is actually the fact that if you have two-step authentication or authentication mechanism that has been deployed by an organization, it will ensure that the information of data subjects that is maintained by that organization is adequately protected. Another technical measure that can also be adopted by an organization is having maybe early detection mechanism. So for instance, you have organizations that if for any reason there is an attempted hack, right, they just get that notification. So they have a software that will immediately notify the HR or the appropriate line manager or the IT personnel regarding that intended hack. So what that does is that it tries to preempt the organization and also ensure that the organization is able to take adequate steps to prevent that from occurring. So beside technical measures, you also have organizational measures. So technical is in the sense of having technical tools or technical measures to ensure the safety of the data that is maintained by the data controller or processor. In terms of organizational measures, we are looking at things like information security policy that is supposed to be maintained by the organization. And that literally would deal with how the information of the organization is indeed maintained, everything about the organization. So in terms of their security tools. Another policy that the organization can also have is acceptable use policy. So essentially, that policy would deal with the do's and don'ts of the organization. So if the organization has a policy that says that you're not supposed to use your private email on office laptop, you're not supposed to use your WhatsApp on office laptop, you're not supposed to indeed send office files to your personal email account. So these are literally tools that have been deployed or policies that have been inculcated by that organization to ensure the security of personal data maintained by that organization. Another organizational measure that can be adopted by an organization is access review. So as opposed to having everybody in an organization accessing a particular project file, you can have designated persons that can access a particular file. So if you're not working on that project, then that file should not be open for everybody. So you can have a line manager or you can have a dedicated manager that would ensure that only persons working on that particular file should have access. What that does is that it safeguards the information in that file such that if you don't need that file, then there's no reason why you should have access. And it tries to indeed prevent any data breach in that circumstance. Another organizational measure that can be adopted by an organization is data processing agreements. So if you're engaging any third party, subcontracting any aspect of the data processing function to a third party, the organization may have a requirement that you should have an agreement that literally will bind that third party to the data protection rules. So it's something that an organization should maintain, and it's something that is indeed a good to have. So what that does literally for the organization is that when you have these tools in place, you would indeed ensure the safety, the confidentiality, and the integrity of the data that is being maintained by that organization. So another principle that we are going to be looking at is accountability and duty of care. Literally, what this principle deals with is actually the fact that it renders or indeed imposes an obligation on data controller or data processor to be accountable in relation to the data in their custody. It even takes it a step further to impose a duty of care on the data controller or processor. So if you're having my data, for instance, you have every duty of care to ensure that that data in your custody is adequately protected. What that does is that I can even sue you for negligence if for any reason there is a data breach, since the Act imposes an obligation or a duty of care on the data controller or data processor. In addition to going through the route of the Data Protection Act to seek redress, I can actually sue you for negligence, because since you have a duty of care, that means you should indeed ensure that you should take adequate measures to ensure that my data in your custody is adequately protected. So we are going to be looking at the legal basis. So beyond the principles, we are going to be looking at the legal basis. So literally what the legal basis, what it deals with, if you recall, when I talked about the principle, I mentioned the fact that for you to process personal data, that you must have a legal basis. That is one of the principles. So the way this is operationalized in the Act is that you have a dedicated part or a dedicated section that sets out the legal basis for processing of personal data. And one of those legal bases is consent. So if you have the consent of a data subject, that would be a valid justification or legal basis to process the data subject's data. Now, that consent in that circumstance must be freely given. It must be specific. It must be an informed consent. So in other words, it must be an unambiguous indication of the agreement of the data subject to have his or her own personal data processed. So what that literally translates to is that if you ask for my consent as a data subject and I just remain mute, that will not amount to consent. So silence is not consent. Pre-ticked box is not consent. So if I'm accessing an app and where I'm supposed to indicate consent, and I notice that the box has been ticked already, that will not qualify as consent, because there must be an affirmative action by me in terms of consent. I must take active step to indicate my consent. And that can be in writing, it can also be oral. But if it's an oral consent, then the onus is on the data controller or data processor to indeed establish that consent was gotten in the first circumstance. So for consent, you must be careful when you're procuring consent from a data subject. You should ensure that as an organization or as a data controller or data processor, that you don't have app with pre-tick box. So if you have pre-tick box, that will not qualify as a consent. If you explain maybe an implication of a particular product to a data controller or you're gathering data and you explained the implication of that processing activity, and that data subject did not actively or take additional step to give consent, the fact that the person was quiet, even after hearing everything that you said, will not qualify as consent. So consent must be freely given, it must be specific, it must be an informed consent. So there must be no misconstruction. So there will be no mistake as to whether the data controller, the data subject intended to give consent or not. It must be apparent. So what that also means is that consent obtained from duress, from fraud, will not qualify as consent. So another legal basis for processing of personal data is where the processing is necessary for the performance of a contract to which data subject is a party, or for the purpose of consummating a contract with the consent of the data subject. So if, for instance, I have a contract with Umar for maybe to supply a particular product to him, the performance of that, I can process Umar's personal data as a condition precedent to the performance of that contract. So if I'm processing his personal data in the context of the performance of that contract, that will be valid. That will be a valid legal basis. If also I'm processing Umar's personal data, maybe the contract has not been consummated, but I actually need to consummate the contract, I need to finalize the contract, and I get Umar's consent to indeed process his personal data in the context of the finalization of that contract, that will be a valid legal basis. Another legal basis that we have under the Act is where the processing is necessary, is actually necessary in compliance with a legal obligation that has been imposed on data controller or data processor under Nigerian law. A good example is the banks. So if you recall, you know that the banks have an obligation under anti-money laundering laws to indeed do KYC on their customers and also to report suspicious transactions. So if in that context, the bank is processing your personal data, that would be a valid legal basis because they have an obligation under Nigerian law to process your personal data for that purpose, and that would not be a violation of that law. So another legal basis is where the processing is necessary to protect the vital interest of the data subject or the third party. Vital interest literally means where the processing is necessary for the survivor of the data subject or a third party in question. So that means it's a case of life and death. A good example is maybe if there's an accident, maybe an accident scene. So you have an accident victim that was rushed to the hospital, and immediately the doctor decided to perhaps extract blood samples to run a genotype or genotype test or genetic test on that particular accident victim. Now that processing is necessary for the survivor of that data subject, and on that basis to be valid. Also, you can have instances where the processing is necessary for the survivor of a third party, another data subject. So if, for instance, you have an accident victim and maybe a mother and a child, and both of them were rushed to the hospital, and you need to do a blood transfusion on the child, and the mother blood is the only blood that matches in that circumstance. So the processing of the mother's personal data, which is the data, who is going to be the data subject in that circumstance, will be necessary for the survivor of the mothers of the child, right? So in that circumstance, it will be a valid legal basis to process the personal data. So another legal basis that is recognized under the law is where it is necessary for the performance of a task carried out in the interest of the public or in the exercise of official authority vested in the data controller or data processor. So this provision deals with enforcement agencies. So for instance, the police. So if the police, for instance, decides to process your data, one of the legal bases that is recognized under this act is if that processing is actually in the exercise of the official authority vested on the police, which is the data controller or data processor in that circumstance, as the case may be. Now, one question that someone may want to ask me is, what happens where the police decides to stop you and then perhaps just stop and search without any warrants? Can they validly do that in the context of the data protection law? So in that circumstance, what you'll be looking at is whether they validly have a legal basis under the Nigerian Police Act or under criminal laws to indeed stop and search a particular person. That will be the question, and that will be the answer to that question. Now, if you look at the Nigerian Police Act, for instance, it gives the police the rights to stop and search only where there is a reasonable suspicion that that person is indeed in custody of a stolen item, or is conveying an item that was illegally or unlawfully obtained. So in those circumstances, under the Police Act, the police can stop you and search and just search you in that circumstance, right? Because they reasonably suspect that you're in custody of a stolen item. Now, the test is the reasonability test that is now the question. That reasonability test is an objective test. So it's whether a reasonable man in that circumstance, so you and I in that circumstance, so a reasonable man in that circumstance would have conducted that search, taking into cognizance the peculiarity of that fact. So beside the police, can a neutral party, can a reasonable man, a third party in that circumstance also conduct that search? So that would be the test that the court is going to take into cognizance in determining whether your right has been infringed upon or your right has not been infringed upon. Now, in relation to perhaps the police stopping someone and then having access to your phone, having access to your laptop without a warrant, under the Police Act, you're required to get a warrant before you can do that. So what that literally means is that even though the legal basis under the Act for processing personal data is in the exercise of official duty, that will still be read in conjunction with the act that indeed vests the police with that official duty. And if there is any violation, you can lodge a complaint before the commission, and you can also go to court to indeed seek redress for the violation of your right to privacy. Another legal basis that is recognized under the Act is where the processing is necessary for the purpose of the legitimate interest, that is pursued by the data controller or the data processor or even a third party to whom that data has been disclosed to. So what this literally means is that you're doing a balancing test. So on one hand, the data controller or data processor is claiming that I have a legitimate interest to process this data, or I have a legitimate interest to disclose this data to a third party. And the data subject, on the other hand, is also claiming that you don't have a legitimate interest. So it's going to be a balancing test that you will do at the end of the day. Now, if you do a balancing test and your findings, the findings of that balancing test is the fact that the processing of that personal data is going to breach the fundamental rights of the data of that data subject, that purpose will be invalid. So in other words, that interest will not be legitimate. If the data subject would not have anticipated that his or her data will be processed in that manner, that interest will not be legitimate. Also, if the interest is going to be incompatible with any other lawful purpose for the processing of personal data other than consent, that interest will not be legitimate. So in other words, if you're relying on legitimate interest as an exception, you must do a balancing test. And you will definitely have to also make records to the exceptions to legitimate interest rule, clearly, which means that if you're processing and is going to violate the rights of the data subject, that your interest under the act will not be legitimate. Or if it's going to be incompatible with other purposes, it's not going to be legitimate. If it's also going to, if the data subject wouldn't have anticipated, taking into cognizance the relationship between the data subject and the data controller or processor, if the data subject wouldn't have anticipated that his or her data will be processed in that manner, then that interest will not be legitimate. So if you're relying on this, I think you should be very careful and you should always do your balancing test to get your end results before you use legitimate interest as a legal basis. So the next thing that we are going to be considering is sensitive data. Now, sensitive data is a subset of data that are sensitive. So as the name implies, it's sensitive. And the reason why it's sensitive is because it has a high risk to the rights and freedom of the data subject. So it's sensitive because the processing of that data has a heightened risk to the rights and freedom of the data subject. And a good example is information that reveals someone's health status. So let's say, for instance, you're processing the data of perhaps an HIV victim, right? A HIV patient, rather. And what that literally means is that if that information is not probably safeguarded, if it's not probably properly managed, there is a heightened risk that that person may be stigmatized, it will actually be discriminated upon, or there may be stigma attached to that person because the person is HIV positive. So the nature of that data is sensitive. And what that means is that there is a high risk that the rights and freedom of the data subject will be impacted if they are not adequately safeguarded. So what the Act does is to induce or introduce heightened protection for that sort of data. So as opposed to going back to the default mechanism or the default provision that we looked at, there is a dedicated legal basis upon which sensitive data can be processed by a data controller or data processor because of the heightened risk to the rights and freedom of the data subjects. Another example of sensitive data is genetic data. If you have someone's data that reveals that the person is SS, there's a heightened risk that perhaps the person may not get a job, or the person may be discriminated upon. And because of that, there is a heightened protection or precaution that must be taken in relation to the processing of that personal data. So the law talks about consent as a legal basis. It talks about vital interests. It talks about performance of contracts, of employment contract, and social security related laws, things like pension, tax laws as one of the legal bases, and medical, and also for medical reasons as well as one of the legal bases. So we're going to be moving to the rights of the data subject. So the first right of the data subject, or one of the rights that the data subject has under the Act, is the right to be informed. Now, I mentioned this earlier when I was dealing with lawfulness, fairness, and transparency as a legal basis. So if you recall, what I said earlier was that the data subject needs to know that his or her personal data is being processed to enable them make an informed decision. So the way you operationalize this, or the way this is operationalized in the Act, is the fact that the Act then talks about a specific right that the data subject has to be informed in relation to the processing of their personal data. So that right to information also covers privacy notice. So if you're processing my personal data, you must issue me privacy notice, and I must have every information regarding the proposed processing of that personal data. Another right that the data subject has is right of rectification. So this is also linked to the right to the principle that deals with accuracy. So a data subject has a right to ask that any erroneous information that is in custody of the data controller or processor be indeed amended or be rectified. So if I think that Umar, for instance, has described me as a male when I'm a woman, right, I can ask that information be corrected. So I can ask that any erroneous information that he has in his custody should be corrected to reflect my true, or the information that represent the correct status of whatever it is that he's doing. So another right that the data subject has is the right of access. So I can actually ask a data controller to indeed furnish me with whatever information that they have about me. So I can write to a bank, for instance, and ask them that I want to have custody of my records with them. So in that circumstance, the data controller or data processor has an obligation to forward whatever document or information that has been requested by the data subject. Another right is the right of erasure or rights to be forgotten. So in relation to right of erasure, so a data subject has a right to request that information that was provided to the data controller or processor should be deleted. So there are two circumstances under which a data subject can actually make this request. One is where the personal data is no longer necessary for the purpose for which it was collected or processed. So if that personal data is no longer necessary by reference to the purpose for which it was collected or processed in the first instance, I can request that my personal data be deleted in that circumstance. Also, if there is no other legal basis for the data controller or data processor to retain that personal data, I can also request that my personal data in that circumstance should be deleted. Now, this right of erasure has actually been tested by the courts, but under the context of the NDPR, not under this act anyways, because this act is new. So it's actually been pronounced upon by the courts. So we are going to be looking at the case of Hillary Ogum and Google. So in this case, Hillary Ogum was convicted of a sexual offense in 2015. So 4 years after serving his imprisonment term in the UK, he was convicted in the UK. 4 years after serving his imprisonment term, he wrote to Google and asked that his information about his conviction with Google should be deleted. Google refused their request, and then he went to court. So when he went to court, he specifically requested that information about his criminal conviction with Google should be deleted from their platform and their search engine. So according to him, that the continued access to that information has led to his stigmatization. Also, he has not been able to gain any employment since then because that information is still available to everybody. And he ordered, or he requested that the court should indeed ask Google to delete that information. In Google's defense, Google contended that information about criminal records, they are not right to, it has nothing to do with privacy, they are public records, right? That the right to privacy or data protection law is actually interested or designed to protect things that third parties don't know about you. So it's not information that is already available or that is in the public domain. So according to Google, in their defense, Google contended that information is already in public domain. So it's actually public record. And to that extent that Hillary Ogum does not have a right to privacy in relation to that information. Secondly, Google also contended that it's actually in the interest of the members of the public to have that information because people should know the kind of person that he is. So it's actually in the interest of the public for Google to continue to retain that information. So the courts in this pronouncement did a balancing test. So they had to look at the rights of privacy of Hillary Ogum against the larger public rights. So essentially the rights to be informed by members of the public about his previous criminal activities. And the court came to a conclusion that is actually in the interest of the public for that information to be retained by Google. So this was a case that was decided during the during the NDPR and not under the Act. So Another right that the data subject has is rights to restrict the processing of personal data. So in that circumstance, if, for instance, maybe I maintain an action against a data controller or data processor regarding the processing of my data, pending the determination of that action, I can also exercise my rights that further processing should be stopped. I can restrict further processing pending the determination of that case. Also, if there's any pending investigation that is being conducted by maybe a third party regarding that processing activity. So in the interim, I can request that the data controller or data processor should indeed put a hold to any further processing activities. So another right that the data subject has is the right to withdraw consent. So this goes without saying. So if I've given consent, I have that right to also say that I'm no longer doing again, that you should stop the processing of my personal data, right? So in that circumstance, I can withdraw my consent. Another right that the data subject has is the right to object to the processing of personal data. So if I've been notified and I've actually been informed in terms of the purpose of that processing, I can actually object to the processing of that personal data, and immediately the data controller or data processor in that circumstance has an obligation to cease processing. Another right that the data subject has is rights not to be subject to automated decision making. Now, the way this right works is that the data subject can exercise his or her rights not to be subject to automated decision making, including profiling, which produces legal or similar effects concerning the data subject. So literally, the way this works is that as a data subject, I can actually exercise my rights not to be subject to decision that was arrived purely as a result of automated processing without any human intervention. So if you arrive at a decision concerning me, and that decision has a legal consequences in relation to any intended subject. So in that circumstance, I can ask that particular decision, that you should not process my data in that manner. So in other words, if you have an automated decision making regarding any intended processing or a processing that has even occurred, I can actually request that the data controller or data processor should not subject my processing to automated decision making. And I will give a good example. So I think for some of the recruiters that we have, you will notice that some of them perhaps may have like a design system, a system that has been configured with defined terms or criteria in terms of undertaking a particular recruitment exercise. So let's say, for instance, I'm recruiting for the position of a data protection officer. So I may have an app or a system that will receive and review an application. Then I will configure that system in a manner that, with keywords or defined words, in a manner that if the application receives any information from a third party and it doesn't have any of those keywords or defined words or defined criteria, automatically the app would send a rejection email to that third party. So there is no human intervention in that decision making. So at the interim, even when the app receives or that system receives the application, there's an elimination method based on what has been fed into that app. So literally what this right does, or what it says, is that I have a right to say that I should not be subject to automated decision making. And even when I've been subjected to automated decision making, I also have a right to ask that decision that has been reached about me by that system be reviewed by a human being. So in that circumstance, if I get a rejection email from that particular system saying that I don't qualify or I'm not a good fit for that particular position, I can write to the data controller, to the recruiter, saying that I need that information or that decision to be reviewed by a human being. And it could be that maybe the way I drafted my CV, I didn't draft my CV in that same terms, in terms of what has been configured in that app. Maybe I used a different term, and indeed I may have the requisite qualification in that circumstance. So what that literally does is that it gives you that rights to ask that whatever information any information that has been reached by that system should be reviewed by a human being. And the data controller or data processor in that circumstance has an obligation to review that decision. And even the data subject also has a right to also make representation. So I can express my views in relation to my qualification. So if I think that there was an error by that system, I can say, sorry, I have the requisite qualification for this job. I think I'm a good fit for XYZ reasons. So it gives the data subject their rights to make representations and also to ask that their information or that decision that has been reached by that system be reviewed by a human being. So that's the way this right works. So another right that the data subject has is the right to data portability. So literally what this says is that as a data subject, I have the right to request that my data be transmitted to another controller or another processor. So I can make that request that maybe Bank A should transfer my information in their custody to Bank B. Now, the way the Act designed or indeed envisioned this is that the granularity of how this would work will also be farmed out in a regulation. So the Data Protection Commission is going to issue regulations around data portability. And the reason why this is important is that sometimes in relation to data portability, you will need an infrastructure. So if I'm making a request that a particular data controller should send my documents or should send my information to another data controller, and there is no integration between, for instance, if I'm dealing with MDAs, and there is no integration in terms of the systems of the data controller that in respect of which that request has been made, and the intended data controller that have actually asked that information should be sent to, and there is no integration, it may be a problem. It may come with significant costs. So who bears the cost? So these are the things that the regulator is going to be dealing with. So another thing that we are going to be considering is cross-border transfer of data. So essentially, Nigeria operates within an integrated and digitally borderless world. So what that literally means is that cross-border transfer is indeed core to international commerce and even domestic trade as well. So we can't even hide away from that. So what the Act does is to come up with adequate safeguards for the protection of personal data that is transferred from Nigeria to a foreign country. So that's exactly what the Act does, and that's exactly what the cross-border transfer of data entails. So we are going to be looking at the safeguards or the requirements under the Act in relation to cross-border transfer of data. Now, the Act provides that personal data should not be transferred from Nigeria to a foreign country except the recipient of the personal data is subject to a law, binding corporate rules, contractual clauses, code of conduct, certification mechanism that provides adequate protection for that particular data. I'll try to unpack some of these terms. Now, binding corporate rules, these are literally rules formulated by multinationals in relation to the transfer of data within the group. So if you have a group of companies, maybe one of them is residents in the UK, another one is in China, another one is in Nigeria, they can have binding corporate rules or practices among themselves in terms of how data should be transferred within the group. So that's exactly what binding corporate rules speaks to. Now, code of conduct. So the way this would work is that the commission will certify specific entities or group of entities to issue code of conduct that will guide maybe a specific sector or a specific group in relation to the transfer of their data. So in relation to transferring data, they have to make records to that specific code of conduct. Now, even in EU GDPR, I doubt if this has been operationalized. I think majorly what they use, or I mean, in terms of the fallback mechanism, I don't think they've indeed implemented the code of conduct rules. So another term that is used in this provision is contractual mechanism. So you can have standard contractual clause that have been formulated or approved by the commission that would guide the processing of data within two countries, within Nigeria and another country. So the core to this provision is that the recipients of that particular data must be subject to a law, binding corporate rules, contractual clauses, code of conduct, or certification mechanism that provide adequate protection for that data. Now, the question that somebody will ask me is, how do you determine adequacy? What does adequate protection for that data? What does it really mean? Now, the Act provides for what you should take into account in determining adequacy. So if I'm looking at, for instance, I want to transfer my data to maybe let's say UK, for instance, and I want to determine whether UK will meet the adequacy requirements. What should I take into account in making that determination? What you can, so the Act gives an indication of what you should take into account. So what you can take into account is whether there is an availability of enforcement of data protection rights. So data subjects in the UK, for instance, did they have an opportunity to indeed enforce their rights in the event of a data breach? If they do, that means that perhaps that country may be deemed adequate in that circumstance. Another one is they even have data protection laws. So if they do, maybe that may actually meet the adequacy requirements. And also another consideration may be whether maybe the law enforcement agency, do they by default have access to people's data? So if I'm calling Uma, for instance, is it the case that a security agency are already monitoring my call? Is that the situation in that country? If that is the situation in that country, perhaps that country may not be deemed adequate. Another thing that you may want to take into cognizance is whether there is any relationship, MOU, or any arrangement between that particular country and the commission that has been established under our Act in relation to the protection of personal data. So if they have any arrangements, any reciprocity, MOU, that will also indicate to you that perhaps that country may be deemed adequate. So what that literally does is that in formulating your code of conduct, in transferring data to another country, you must indeed take into cognizance, or you must indeed ascertain that whether or not that particular country is adequate in the first instance. So as a fallback or as a default mechanism, the Commission has powers to designate certain countries, regions, specific sector as adequate. So literally the way this would work is that the Commission will have like a list of countries that will be designated as adequate. And where you're transferring to any of those countries, you need not do any other thing. So no additional step is required because they've already designated those countries as adequate. Even in the designation of those countries as adequate, the Commission is also supposed to look at the adequacy requirements to even make that decision in the first instance. So what that means is that if that country has been designated as adequate, then you don't need any further, no additional requirements will be needed from your own side in terms of transferring that data. So you can just proceed to transfer data with that particular country. So in terms of where we are presently, so if you look at the NDPR, the NDPR Implementation Framework 2020, there is a white list that is contained in that NDPR that literally lists about 44 countries as having adequate data protection laws. So what that literally means is that if you're transferring to any of those 44 countries, that will be fine. Now, somebody may ask me, why are we talking about the NDPR when we already have NDPR Implementation Framework, when we already have data protection law? So if you look at the data protection law, it has a transitional regime. So what it does is that it literally preserves all existing laws, all existing regulations, policy, guidelines that were issued by NITDA or the Data Protection Bureau. So it preserves them until or pending when they are altered, revoked, or withdrawn. So to the extent that those instruments, they've not been altered, they've not been amended, they've not been replaced by the newly minted commission that we have under the Act, those laws, those instruments are still valid and we are still required to comply with them. So that means in determining adequacy, you can safely transfer data to any of the whitelist countries that we have under the NDP implementation framework. So the commission is also required, or the commission has been empowered to approve your code of conduct. So it's not just sufficient that you have a code of conduct. It must be approved by the commission. It's not sufficient that you have binding corporate rules. That must be approved by the commission. So your code of conduct, binding corporate rules, or contractual mechanism or standard contractual clauses must be approved by the commission before you can even indeed fall back on those to transfer data outside the country. Now, outside the adequacy requirements, so if you don't want to use any of the code of conduct, binding corporate rules, you don't want to use the whitelist. Now, there's another safe harbor provision or other safeguards that we have under the Act that provide legal basis for the transfer of personal data to outside the country. So So other than the adequacy framework, whitelist, you can also fall on other safeguards that we have under the Act. One of those safeguards is consent. So literally, if I'm transferring personal data in relation to a data subject that has already consented that it should be transferred to maybe to the UK, so that would be sufficient. So I wouldn't need to do any other thing to the extent that the data subject has given consent. So if it's necessary for the survivor of the data subject, so in the circumstances that I explained earlier, if I need perhaps to send the mother and child outside the country to have the blood transfusion or to have whatever to get medical treatments, I mean, in that circumstance, I wouldn't need any other thing to be able to transfer that data, right? I can actually transfer their data. So if for instance, I'm actually the hospital in Nigeria and I need to transfer that data to another hospital in the UK, for instance, to the extent that transfer is necessary or that processing is necessary for the survivor of the mother and child, that will be adequate. So literally, the Act provides for other safeguards beyond the whitelist, beyond your adequacy requirements that you can also fall back on in terms of determining whether data should be transferred outside the country. Now, another thing that we are going to be considering is the obligations that have been imposed on data controller and data processor of major importance. Now, the first question is, what exactly is data controller or data processor of major importance? Now, data processor under Section 65 of the Act, data controller or data processor of major importance is indeed a processor or a controller that processes or intends to process data more than such number of data subjects who are within Nigeria as the Commission may prescribe. So in other words, by reference to volume. So that volume is to be prescribed by the Commission, or where the data controller or data processor is processing or intends to process personal data that are significant to the economy or society or the security of Nigeria, that automatically, as may be designated by the Commission, so that automatically would be covered, or that controller or processor will be regarded as data controller or data processor of major importance. So we'll look at the obligation that have been imposed on data controller or data processor of major importance. One obligation is the requirements to engage the services of a DPO. So that is data protection officer. So under the Act, a data controller and a data processor of major importance is required to engage the services of a DPO. That DPO may be an employee of a data controller or processor, or may even be an independent third party that perhaps is engaged under a service contract. So literally, what DPO is going to be doing is to ensure compliance. So it's to ensure that that particular organization complies with the requirements or the provisions of the Data Protection Act. Now, one may ask me that, well, that this concept of data protection or data controller of major importance and processor of major importance is new, and there is no designation that has happened. So the Commission is here to designate. So what then happens? Does it mean that we are no longer required to have a DPO? So we are required to is it the case that we are now obligated, or we should wait until the data commissioner or the data commission, the Data Protection Commission, designates who a data controller or data processor is by reference to the volume of the data subjects data that they process at the end of the day? The answer is no. The status quo is preserved. Now, as I have on my slide, so even though the Commission is yet to designate data controller or data processor of major importance, if you look at Section 65 of the Act, it preserves all other rules and regulations issued by NITDA and issued by the Nigerian Data Protection Bureau. So the effect of this is that the Nigerian Data Protection, the NDPRU and the NDPRU Framework 2020 are automatically preserved. So all status quo obligation, it remains. So whatever obligation that you've been complying with under those regulations, you're required to continue complying with those obligations. So if you look at the data protection framework, so in terms of maintaining or having a DPO, so it provides that where the controller or processor is a government agency, is an MD or an institution, automatically they are required to have a DPO. So another requirement is where the data controller or processor is actually processing sensitive data I've explained this earlier in terms of what is sensitive data that has a high risk to the rights and freedom of the data subject. So when you're processing sensitive data, regardless of the volume, automatically you're required to have a DPO. So when you're also processing large set of data, in that circumstance, you're required to have a DPO under the data protection implementation framework. Also, when the data is also critical to the national database or things that relates to security of the country, you're also required to have a DPO in that circumstance. Another obligation that is imposed on data controller and data processor of major importance is the requirement to register with the commission and indeed update their registration with the commission depending on the nature of their processing activities. So under the Act, there's an obligation imposed on data controller or data processor of major importance to register with the commission within 6 months of the commencement of the Act. And where there is a change in the nature of the processing activities of that data controller or data processor of major importance, the data controller in that circumstance or processor is required to also update that registration. So as I said earlier, even though that designation has not been done, presently under the NDPR, you will notice that that data controller and processor, certain data controller and processor are actually required to do an annual audit. So what the NDPR says is that a data controller or data processor that perhaps processes data of more than 2,000 data subjects, you're required within a year, you're required to do an annual audit, and file your returns not later than 25th of March every year. So if you process data of 2,000 data subjects, you're required within a year, you're required to do an audit and then file your returns to the commission. So that provision is automatically preserved because it has not been altered or amended by the commission. Now, if you also process data of more than 1,000 data subjects within a period of 6 months, you shall also be required, or you're also required to submit an audit returns or an audit in a manner that will be prescribed by the commission. So if you process data of more than 1,000 within a period of 6 months, the commission may request that you do an audit in a manner that will be prescribed by the commission. So next is enforcement. So we've talked about the rights, we've talked about the principles, we've talked about the data controller of major importance, data processor of major importance, cross-border transfer. Then the question that someone may want to ask is what is the effect of non-compliance? What happens if there is a violation of the provisions of this law? What happens? Now, if you look at the Act, you will notice that the commission has an obligation or is indeed empowered to issue enforcement notice in the event of any violation of the provisions of the Act. So as a data subject, if I lodge a complaint to the commission that Umar has breached my personal data, and after investigation, they can issue an enforcement notice against Umar. So that enforcement notice may take different forms. It may actually require Umar to indeed remedy that violation. So if, for instance, the complaint that I lodge is in relation to my ability to exercise my right of ratification. Maybe Umar has information about me that is not accurate, and I've requested that he should correct my information, and he refused to do that, and I decided to lodge a complaint. So the commission can actually issue Umar with an enforcement notice, and that enforcement notice may require him to indeed remedy that violation, the violation of my rights. So an enforcement notice may also require him to pay compensation, and the compensation to be paid is actually by reference to the turnover of the company. So you have maximum penalty and you have standard penalty. So depending on the exact terms of the enforcement notice, you may be required to pay compensation to the data subject for the violation of the data subject rights by reference to your turnover. So where an enforcement notice has been served and the data subject indeed fails to comply with that enforcement notice or enforcement order, the data subject can indeed be prosecuted or can indeed be taken to court. And where found liable, the data subject may also be fined. based on the maximum amount or the higher amount that is stated under the act. So this brings me to the end of my presentation, and I think at this junction, we can take questions.
A round of applause for Barrister Celestina. Please, if you have your hands, you can clap. This is a dish well served. If it's so full now, we should be, licking the plates and drinking water to digest the soup. Quite a lot to discuss. I'll just type in on the chat on the WhatsApp group that this discussion is endless, because my notes is filled up with jottings and I don't know where to start from. Thank you, Celestina, for this awesome. In fact, I had no reason to stop you, as in because you were just dishing out the Ofurere as if we are celebrating Ofala. So we just appreciate you for your time in preparing this presentation and for coming through. I'm not going to ask people to ask questions because our time is fast spent. But let's just take 2 questions. Next week is the roundtable discussion. Martins will be coming back with Celestina for your questions, and we'll take a pause at for now. We're having investment strategy upper week. So next week we just take question and answers. Martins and Celestina will be around to take your questions, but we just take 2 questions tonight. If you have any questions to ask, just unmute yourself, ask briefly. You need to shut down in the next 2 minutes, please. Any question to ask or comments, just 2 persons and we are done for today. Okay, so Anne on the chat group is asking, can a DPCO who doubles as a DPO to a firm be allowed to audit or file privacy audit report for that firm? If yes, will the DPCO not be biased in his judgment? What does the NDPC say to this? That's the question from Anne. Can we take the last question before she just responds to 2 of them? The last question, I'm very worried right now because I have this, we have this platform where people come to download our templates and they fill our forms. Those data have been kept there for like God knows when. And sometimes people apply for, let's say, a job position, and they are being sent adverts for other company products. These are burning issues that we see every day. I know a particular company that I was applying for, back then, 2019, 20, 18. I kept applying and they never accepted me. So one day I met one of them in Abuja. We were discussing over dinner. And I asked her, as in, why are you guys not even calling me? She said, you can't even see my CV anywhere. So the system is programmed in a way that once it sees your CV and you don't tick a particular box, it just throws you off the process. You understand? Meanwhile, that same company, somebody inside that was calling me to, if I'm interested in a position in one state. Meanwhile, I've been applying for that same position and nobody is calling me. So there's a lot of issues to be discussed under this act. And I don't think we'll exhaust that in 2 hours or in 2 meetings. So we just keep watching and seeing what will happen as the event unfolds. So just the last questions, you can just respond to that question from Anne. Since nobody's asking again, over to Celestina. Let's respond to Anne and we'll wrap it up tonight and wait for next week if we have questions.
Okay, so in relation to, so my response to that question would be that I think the core to the function of the DPCO is transparency. So when a DPCO is carrying out an audit, part of what you're supposed to do is to act as a neutral third party. You're supposed to look at things from an independent standpoint, right? So from that perspective, the question would then be that can a DPCO double as a DPO? So the act does not speak to this issue, and but the concern I have is that responsibility of being transparent, of being a neutral third party will no longer be there, because ordinarily you should be licensed to be doing an audit for third parties and not auditing yourself. So if you're a DPCO and you also double as a DPO, then in that circumstance, the audit will be biased in my view, and that would not be appropriate. But in terms of whether the Act speaks to this, the Act doesn't speak to this because it just deals with general licensing requirement for a DPCO, literally just saying that the commission can indeed license or accredit persons that can act as DPCO, but it doesn't speak to whether you can indeed double as a DPO in that circumstance.
Thank you so much. I'm going to wrap it up here so we can prepare for the week ahead. We'll be sending a small Google form. Now I know better. I'm not going to ask for your name or email address. just ask your question to prepare for next week. So we can just coordinate next week properly. Just a simple form, your question, that's all. Your question, maybe you just add your job interests or job areas. We'll ask for your name or your email address before you come and see me now for data protection and privacy. So please, when you see the form on the chat group on WhatsApp, on Facebook, just fill the form, ask your questions. We would like to take next few questions. I already have 10 questions that I've listed out to ask both Martins and Celestina, and I've added more tonight to those questions. These are questions that affect me personally as a professional. You know, for example, medical history. Some hospitals, you ask them for your medical history, you ask to pay money for it to be transferred to another hospital. Those are the issues we'll be discussing. You know, what do we mean by data minimization? What is the limit of storage for those data? We that have bloggers that retain private information of people. You know, to what extent would they keep those information in the database? You know, sometimes people apply for jobs, you know, send their CVs to us, we recruit for companies. To what extent should we keep those CVs? Should we keep those information, you know, in our databases? So these are the things we need to discuss. So I have my questions arranged for next week, Sunday, and I'm sure we want to see your questions also on Sunday. Thank you, everyone, for coming. We'll be back again next Sunday. Sorry for the time taken today. It was worth it. We don't want to stop Tina on the presentation. Next week, we'll come on the roundtable. Martins will be here from the part of career opportunities, while Tina will be here from the legal aspect, and we'll discuss more next week. Thank you, everyone, for coming. Have a wonderful week. Remember, your week starts today. Plan, prepare, and finalize your preparations for next week. And God bless you. Thank you, and over.
Thank you, everyone.
Wondered what I would become. That experience taught me about the hard process of